When you are risking arrest on the front line of a civic action, there's two things you should know at all times. The organizers and others have your back, as much as being arrested or being questioned or held by police can sometimes feel like a very isolating process. There are others involved with you. That support is integral. When you are taken into custody by police, and the how and why an arrestable offense is, we're going to get to in a little bit. I just want to begin with some of the greater contours. So when you are taken into custody, whether it's formal custody after arrest, whether you're being held for questioning or otherwise, legal support is there to track you through the pipeline of the judicial system. Even if it's not going to be a criminal arrest, even if you're just given a ticket, even if you're just going to be in custody for 20 minutes or 2 hours, it's important that the people who are taken into custody are tracked. No one's left behind. This is the legal face of support and solidarity. What I've noticed is that when people support one another through a legal process, this is integral to building sustainable movements and to making yourselves more effective. Now, whatever an action might be, at a port, on a bridge, an airport, an ordinary street, whatever it might be, everyone individually has to come to a decision about assessing their own scale of risk and deciding to accept the responsibility of an action and the incumbent risk to be arrested. No one can force you to make that decision. I think it's important that these discussions happen collectively so people are informed of that risk. There are a series of likable arrestable scenarios. I'm going to ask Michelle to maybe expand on that a little bit.
Hey, Michelle.
Sorry.
Maybe just before we get into arrestable issues, there's just a few other things around like legal support on an introductory level I thought I might add, if that's okay, Vic.
Yeah, please.
Yeah, and for folks who don't know me, my name is Anna. I work with Pivot Legal Society. Most of my work has been in the tent city context, and things can be a bit different there in terms of what legal support can look like. One thing I wanted to name just off the top is that, as Vic said, we're bringing our personal, this is more like information that we have. It's based on our own experience and also the learning we've done, but obviously there's expertise in the room and there's going to be people who have been facing arrestable situations that we haven't faced and will have information to share with us as well and with other folks here. So by all means, as we go, if you feel like you have something to add or that we're missing something, like raise it. And that kind of goes to the bigger picture piece that I just wanted to name off the top about legal support, which is that, movement legal, and I think all the folks on this call individually, we come from a place where legal support doesn't mean lawyers, and it means a certain kind of knowledge and support for each other, and one that is grounded in, to the extent you can, understanding the legal system and understanding criminal consequences so that you can be strategic about your actions. And there'll be times where lawyers who are actually trained in that and certified on that will be needed. That will be a narrow set of circumstances, like who are you going to call from cells? Well, legally, the only person you have the right to call is a lawyer. So that might involve that. But wherever possible, the hope is that we share information such that it can move away from something that's lawyer-centered and become information that you hold as a group. And that's also really important because there can be a huge gap between what the law says in the letter and what actually happens to people on the ground. And I'm sure many of you already know that. There's what the rules say cops can do, and there's what cops do. And there's what we can tell you, you technically can say, and then there's what can practically happen, especially if you are someone who is racialized or otherwise marginalized, if you say those things. So kind of everything we say today to hold it in that context of like, there can be a real gap between the technical legal situation and the practical on the ground reality. And it's about trying to give folks a bit of a foundation so that you can build your collective knowledge and support each other in this way in the moment. Yeah, so over to you, Michelle.
Thanks, Anna. Thanks, Vic. I don't really know what else I can say to kind of re-amplify what my colleagues have already said, so I won't try. We are going to talk a little bit in greater detail about what happens in an arrest scenario, but very broadly speaking, it's very context specific. Usually there is some level of warning before you become in an arrestable situation. Usually the police will give some kind of warning like, you know, if you remain in the situation, you are at risk for arrest. Usually they will start to demarcate places where if you're on the outside of the demarc place, whether it's someone standing on a sidewalk versus in an intersection, someone standing on a footpath across a bridge versus on the actual road bridge of itself. So there tend to be sort of physical demarcations of space. Again, it's context specific. If the action is taking place in what might be considered a more organized setting, you'll be more likely to be aware of what's happening and to be able to respond with the knowledge that you already have about your rights in arrestable situations. As you've seen in other contexts, Bearded Warriors is a very poignant example that comes to mind. Situations can devolve where it becomes very violent, very chaotic. You might not be in the situation where you are with the intent of considering yourself arrestable, but you will find yourself in that situation. Different contexts between whether you're being arrested on an injunction or whether you're arrested for general criminal code mischief offenses. Again, things that we'll go into in further detail later on, but that's my thoughts for now.
Awesome. So I think when we talk about risking arrest at an action, I want to make the observation that it's something that everyone should arrive at, like I said, independently, but it's also part of a collective tactic. And it takes a lot of individual courage for people to decide to make that decision. Risk of arrest means something different for a member of the queer community, BIPOC, or women than it does for someone like myself, for example. Arrest is a time where you no longer have control over your own body, because when you're taken into custody, others will control where you move, how you stand, what you do. And I don't mean to say this to scare anyone. It's just part of a planning process around expectation, risk, and the day of the choices you make. There's a significant difference between blocking a street and a road and being on the dividing line between public and private property. There's a host of different legal challenges there. I can't comment on an XR strategy, as effective as they might be, on where targets are made, but it's something that everyone has to think about individually as part of the collective. What risk am I taking on? What are my duties on the day of? And will I be risking arrest? And what are the incumbent responsibilities? So let's think of what is someone's goals and what are our options? So if someone makes the decision to risk arrest, they're gonna have to ask themselves, what have I done to prepare for the day? What am I doing the day of? And what am I taking into the risk management myself? So training yourself of your available rights is probably the first step. Second, in order to be tracked, in order for someone to be responsible for you, whether it's the buddy system, I don't know if you're pairing up in small collectives, but you need to fill out a personal information form. I would always opt for literally pen and paper. Okay. And that's held by someone that's probably not at the front line, so you can be tracked. If you have medical or other special needs, you need to inform whoever's tracking you, because that can, I mean, on a 99% chance for a non-serious violation, no one is held above, let's say, 3 to 6 hours. Okay. But if it's necessary, because people have individual medical needs, you need to inform legal support of those medical or special needs. Again, because when you're being held in custody, you no longer have the right to receive any materials from the outside. You no longer have, reduced rights to make requests upon the police and authority. There are consequences when you're facing arrest and facing a charge. Now, we've seen in the past varying responses from the police at public actions, and we've seen varying responses after the police have laid charges from the Crown, whether those charges proceed. There's a broad range of factors that mitigate against the risk of what might happen when one is arrested or when one faces a charge. Think about one's immigration status. Think about one's employment. Think about one's personal responsibilities. If you have a partner, if you're responsible for someone else, you will be out of contact for 3, 6 hours or a certain period. I'm going to ask either Michelle or Anna to speak a little bit about immigration status and some of the risks that you might run facing a charge or being arrested.
Okay, I'll speak quickly on the immigration status component. Again, I would recommend that if you do have individual questions in regards to your immigration status, it's very context specific. So feel free to reach out to myself. It oftentimes depends on whether or not you're here on a work or student visa, or you're already here as a permanent resident. For people who are here on student and work visas, again, it's required that you've already been convicted. So just mere arrest is not enough. If you've been arrested but charges aren't approved, then you haven't been convicted. So that is the first component. Second of all, it does depend on what you've been convicted of. So something that is relatively minor, such as a mischief arrest, which in my experience has been what most people who've been arrested actions which do not involve injunctions are often arrested for mischief, intimidation, these kinds of lower level things. You have to normally be convicted twice of a summary offense before issues of inadmissibility due to criminality start to come into play. If you were convicted of something rather more serious, then it's possible to have these things be triggered sooner. And again, I think if you're here on permanent residency status, it depends on the sentence that you serve. If you serve more than a 6-month term in prison, then that is when you can be barred for inadmissibility. But I have not, in my experience, seen somebody who served that amount of time in jail in the context of just regular actions like these in the city. So again, if you have any more specific questions, feel free to reach out to myself and my colleagues.
Awesome. So the day of an action, when the actual risk is realized, in preparation for such an action, what are the steps we take? What do you bring? And I want everyone to keep this in mind. An ID that clearly shows your first and last name and your face. Usually pen and paper, I would highly recommend. And if necessary, a prescription pill bottle with at least 24 or 48 hours of medication. Again, I posit that by saying, I'd be very surprised if anyone was held 24 hours, but it's just in case. Things you're going to leave at home. Absolutely no weapons. And weapons could be a Swiss Army knife on a keychain. Weapons could be anything that's maybe 2 pounds or heavier that's made of metal or something that won't break easily. Any kind of drugs at all. Any kind of drugs. And I say that because although cannabis is legal, I still would not recommend having it on you for a host of reasons. Your wallet. So what I mean by wallet is a transit card, credit card, anything other than a single piece of ID. If you must bring your phone, and that's really like a must. I don't know if photography and social media, etc., plays into a specific media strategy at some of these actions, but I would often tell people don't bring your phone under any circumstances. But if you are, please change it so there's a numeric password that only you know, not fingerprint and not facial recognition. I'm going to say this. In British Columbia, police do not need a warrant to find their way into your phone. And what kind of critical information could they get from your phone, you're asking? Well, they could identify the fact that this session took place. They could identify who the leadership is of XR that invited you. They could find out what the planning process was. They could route all of the members of the collective. These are all pretty dangerous things. And you might ask yourself, well, Vic, I didn't write that in text. It doesn't matter. They have personal information about you they can seemingly threaten you with to extract that kind of information. One thing I want everyone have done the day of an action is in black or blue marker, a permanent marker, write a hotline number, a phone number of legal support on your arm or on your leg. That way, it's easily accessible, it's within sight, and if things go a certain way, you need to call for legal support, it's available. Don't ever count on having a phone or a wallet with you at an action, as chaotic as some of them may be. And again, on how basically the limitations to your corpus that begin as soon as you're taken into police custody, those are activated. Now, hypothetically, if one is at an action, you cough on pepper spray, you're separated from the group, someone grabs you by the arm, someone explains, I'm VPD, I'm RCMP. You identify yourself, you're in plastic bracelets. They might give you a promise to appear or a summons, which are provincial charges. You're still going to be hanging out for 5 minutes, 15 minutes, 2 hours. I can't stress this enough. Do not speak with anyone under any circumstances when you're in custody. That means if you're in a cell next to your best friend or an XR planner next to you, nothing you say is private. And you wouldn't believe some of the stories we've heard about someone in the back of a van, some scraggly hipster looking guy he hasn't seen before with a UB Street Forestry t-shirt on, gets in with handcuffs on. Well, guess who the undercover police officer was that day? Jumping from van to van, asking questions. Hey, who did you come in with? Hey, where are we meeting up after? Hey, just that's how nefarious it can be. And I just think, sorry, I just saw a question pop up. I'll get to that in a second. I basically, I know it's a hip term right now during COVID, but I want to bring that up, the precautionary principle of communicating when you're in police custody. It's incredibly important. So have a plan about what you bring that day, who knows you're there, support number hotline on your arm, and stick to the plan. The more simple you keep it, the better off everyone is. So am I arrested or am I not arrested? Am I being detained? 3 different legal categories. If you're not under arrest and you're not being detained for questioning, you're free to go. These are 2 very simple questions you can ask politely to any member of any police force. Am I under arrest? They will say yes. Now, at an action, if it's a little disorganized, remember, they might put you under arrest and arraign you 30 minutes later, might put you into custody, tell you what you're under arrest for, and only give you a summons 2 hours later. But remember, if they say you're under arrest, you're in their custody. If not, you're free to go. If they say you're being held for questioning, 60 seconds later, you can ask again, am I still being held for questioning? 60 seconds again, am I still being held for questioning? It's not an indefinite period. And the only questions you have to answer is, my name is Vic Handa, it's the 25th of March. That's pretty much about it. If you are arrested, remember, questioning can lead to arrest. It might be abrupt. It might be somewhat traumatic to some people, having someone twist your arm, push you against a police car, or grab you by the wrist. You have the right to ask what you're being arrested for. And there's a broad range of charges available to police at an action. Often it's limited to, it won't be a road traffic violation. It'll be something like mischief. It's probably 2 or 3 key select summary offenses that they'll bring up. Things you have to tell police after you're arrested: name, address, date of birth. What I said earlier about not speaking to police, after you've given those identifying factors, you have a right to silence and a right to counsel. That right to silence is to protect you and protect others in the group. The right to counsel means that you're not alone in there. It means that your own legal education has reached its limit. And like Anna said earlier, someone can lend a hand. It's someone you're going to call. Police, in the space of an action in the immediate vicinity, can stop you and can search you. Now, at the time, you might feel like the search is not justified. But that type of a complaint will be retroactive in the moment. So I want to prepare you that police might ask you to empty your pockets, and if you don't, they might do it for you. I would tell you, though, to verbalize, I do not consent to a search. And be comfortable saying that. It's not a unique challenge to a police officer's authority. They hear it all the time, but you need to make that clear. And feel free to say it calmly and clearly more than once if necessary, okay? When you are placed under arrest, and you'll know this because you're taken into custody, police have the right to seize your possessions, including anything in your pockets, whether that's medicine, phone, etc. I'm going to ask Michelle to contribute a little bit now on what detention in custody looks like.
Okay, thanks a lot, Vic. So again, something that I've kind of spoken a little bit about before. I guess we can start with the detention part first. I mean, the police are, there's this whole line again about, am I being detained or am I free to go? That's kind of the trope thing. If you are being arrested, again, you're likely to be taken into custody. There are some situations where we have seen this not happen, but for instance, if there's an action where a lot of people are being arrested at the same time, the police may set up tents to process people on site. That also has the benefit of people going through the process faster. There is a little bit more transparency in that process, but again, it depends on what kind of action is taking place, and again, how many people are involved. If you are being arrested, again, the time periods that we've seen tend to be around 3 to 6 hours to be released, depending on time of day. If you are being arrested closer to 5, you'll be released quickly that evening. But we've also seen actions, including bridge actions in the past, where arrests tend to take place closer to midnight. Again, processing times will mean that you may be inside detention for longer. It will mean that people who are offering jail support will likely have to stay there until maybe early morning. If you are recognized or understood to be someone who is active as an organizer and has been arrested in the past for similar actions, has a record for being arrested by the police, your process may take longer. You may need to have a hearing the next morning or later on that day for a bail application for you to be released. Again, very context specific, and also depends on what your history and to the extent to which you're known to the police. But again, they can't keep you in detention for more than 24 hours without some kind of bail hearing taking place. So in the worst situation, I would say that 24-hour period, while very uncommon in the past few years for actions, is not going to be entirely unheard of. In terms, we have had instances where people have refused to sign documents. So when you're in detention, the police will usually give you something that's called an undertaking, which lays out certain conditions that you have to abide by in order to not breach your conditions. And what this often means is that you are not to attend the site where you were arrested. So in the past, where arrests have taken place at the Port of Vancouver, these people were not allowed to attend at the Port of Vancouver site at the intersection where they arrest again. So if you have particular concerns, i.e. you live close to this area, you work close to this area, you have to commute through this area, sometimes I have to say bluntly, depending on who you are, sometimes people who feel like they're able to challenge police officers, able to, there's an opportunity for you to do that. But at the same time, if it was someone like me, if it was another BIPOC, if it was another femme, I might not personally feel comfortable challenging police in those particular circumstances. And when I take the phone call and I talk to these people while they're in detention, I will say, listen, it's our job as the lawyers to vary these bail conditions so that we'll take care of it if you don't feel safe where you are speaking to police without this visibility, with this transparency, it's the job of us as lawyers to take on that role. But again, if you want to be a little bit more hardcore, that is something that you can also try to talk to the police officers about changing your conditions. Again, promise to appear. It's just a promise that you or the lawyer representing you will appear the next court date. That's all it means. It doesn't mean that you admit to the offense. It doesn't mean that what he did was wrong. It just says, I will appear at this date a month or two in the future. That's all it means. What else? What else is there? And I guess the next, yeah, obviously, you have the right to talk to the lawyer. Normally the number of the lawyer will be written on your arm. And then, if you have any immediate concerns, let's say you've sustained injuries during your arrest, you have medical concerns, you have a concussion, you feel like there's something unsafe, then that is also the opportunity for you to talk to the lawyer. If you have any particular needs for when you get out, that, we as legal support can forward over to the organizers about needs. You need, I need someone to make sure that someone's watching my kids, and that, mom, dad, they're going to be home a little bit later than I expected. That's all information that you'll be able to relay onto us and to the people who are offering legal support, so that those concerns can be met too. Finally, in terms of charges, again, very context specific. There is a huge caveat, and the caveat is, have I been arrested for breaching an injunction? It's something that we've encountered if an action were to take place in the Port of Vancouver on CN rail lines. I believe some people on this call might have already had experience going through that situations. But if you're being arrested on criminal code charges, what we often see are mischief. What we often see is intimidation. There is a video of police officers on the body cam footage going to some random person on the street, eating a sandwich rather nonchalantly, and the police officer saying, if you don't get out of this intersection, we're going to arrest you for intimidation. And then the guy eating the sandwich being like, I'm not intimidating anybody. But that's something that you could encounter as a possible charge. Slightly more amped up situations could be obstruct peace officer, could be assault peace officer. And again, opens up to potentially broader risks if something like employment immigration is a particular concern. But again, ultimately, what the police decide to arrest you for is not the same thing as what you're being charged with. The police are not lawyers. It's ultimately up to the Crown Counsel, the prosecutor, who will go through the police file and determine whether or not what you have been arrested for, has met the actus reus, like the physical act, mens rea, mental intention, and also if it passes the public interest test, which again is in the past why we've seen certain charges not be approved by Crown, because for them it fails the public interest. I can't guarantee what's going to happen this time, or future times, but it is something to potentially consider.
Michelle, without mentioning any specific defendant from the past, just give me an example. What kind of charges have come up at previous actions? Might have been stayed, or then what did the Crown actually proceed with?
It is, out of recent circumstances, people who have been arrested on criminal code offenses where their charges have been approved, i.e. have been prosecuted, have tended to be people who have been known to the police and are recognized by the police as being major organizers. That is, and probably what we might see in the future is people who've been arrested in previous actions before charges weren't approved, but then they decide to be arrested again. We're kind of coming into that territory that is somewhat untrodden ground when it comes to the actions which have been taking place in the past few years. If you have been previously arrested for a Kinder Morgan injunction, the police will have a record that you've been arrested, but they won't, for the purposes of a criminal conviction, being found guilty of criminal contempt of court was not the same thing as being found guilty of a criminal conviction. So again, this would be stuff that the lawyers may need to argue that, the circumstances are slightly different. Slightly roundabout way of answering your question, Vic, but feel free if you need any further clarification on that.
Maybe you could share with us, what are you handed when you're given a summons? And what's the timeline between, okay, I'm at an action, I'm charged today. When is my first appearance? What the process looks like from that perspective?
So what we normally have, again, is a sheet of paper, which is called a promise to appear. The top part will have your identification, what you've been arrested for. So we've seen instances of these where we'll have like mischief and intimidation. Honestly, these people aren't even doing anything intimidating, but I feel it could just be a tactic for them. I won't say anything more on that. And then the bottom half will be your conditions that you've agreed to, i.e. keep the piece of beef good order, do not attend particular areas, and then a signature. They won't give you the police file, the police disclosure, until your first appearance date. Pre-COVID, this would probably be a few weeks, but with COVID, your court dates could be longer. So it could be like in a 2-month period rather than a 1-month period. What we were dealing with before with actions last year, where people were waiting like 8 months, some 6 to 8 months for the first appearance dates. But now that there's a little bit more certainty with how the courts are operating with COVID, I don't think people will be waiting that long.
Michelle,
Wonderful.
can I ask a follow-up question? Two things that you've mentioned in kind of previous sessions. One is kind of the difference between passive versus active resistance and kind of the chances of charges for both of those.
Okay.
And then the other one was a little bit about how, in terms of some people signing conditions and other people trying to wait till the morning and seeing what they can get in court, and how sometimes that can be a way for people to work as a collective. Because if some people get better conditions in the morning, that can make applications to vary everyone else's conditions easier. So I thought maybe you could chat a little bit through those two things.
Yeah, I'll probably deal with your second question first. This was something we encountered with arrestees with Navigans/Crab Park, where the first set of arrestees were given very, very broad conditions, whereas people who were arrested later on were able to get less broad conditions. And this kind of touches back with what I said earlier, where I guess a certain group of arrestees who maybe didn't feel or maybe, I don't know the best way to describe it, but without casting value judgments, these are people who thought, okay, well, I'll just challenge the police and say that we had that our conditions are very restrictive. So what the cops did was that they contacted the lawyers for the Port of Vancouver, and they were able to kind of negotiate, quote unquote, less restrictive conditions. But again, it was pretty context specific, and ultimately people who had the more restrictive conditions were still able to get them varied through lawyers inside. So ultimately everybody got the same set of conditions. It just took longer for some people rather than others. In terms of people who are kind of organizing inside the prisons, unfortunately, that's not stuff which I have lived experience with, but I'm sure that there are other people who are operating and organizing these circles who, would be able to kind of explain, the actual process behind them too. Because like as Vic says, there's no conversation that's necessarily safe inside prison. So to what extent can you kind of organize and work together when oftentimes you're being kept separate from each other? You don't want to say something which could, trip something further and, broaden the net where people could be put in more risk or danger. It's a very, thin line, And in terms of passive versus active arrests, one example that we can kind of think of is the arrest of Kinder Morgan, where people just decided to go limp and then they had to be stretched away. There is a line in one of the cases which is that passive resistance is not resistance. So if you want to go limp, you wouldn't pass the legal test for obstruct peace officer, or because
Michelle,
yes.
could you give some context, physical context of time and place to what you're talking about? When would people go limp? Just maybe expand on that a little bit.
Okay. So I guess physical context, as in like people going limp, or?
At
Okay.
what point are they going to be resisting?
Okay, so I'm gonna use my fan again as an example. So someone who did face criminal charges locked their legs underneath a heavy metal object. So if you take my fan here and I go like this with my fan, and then now I'm kind of resisting with like a harder object. So therefore, it's up to the police and up to the lawyer to say, well, now you're resisting. Someone who, again, tied their legs under a hard metal object, tied their legs with a jacket. The charges for obstruct peace officer were approved in those circumstances. We often see people who link arms sitting down while being arrested. In the context of Kinder Morgan arrest, they weren't given any more severe charges than the people who didn't link up arms. But sometimes it's up to how the prosecutor is feeling that day, and whether or not they want to make this be a hill for them to fight on. So it's not always very clear cut, but broadly speaking, when people are being arrested and one person's linking arms with somebody else, and somebody's going limp and somebody's just standing there, in our experience so far, they've all been arrested for the same things. Their outcomes were ultimately the same thing. But again, the person who was locking their legs together was someone who was recognized as an organizer. So it was a bunch of different factors which made this person feel a particular legal consequence that others who could have been doing literally the same thing didn't. So again, unfortunately, it's not always clear cut.
Wonderful. I just wanted to share two things. The first is at an action when being approached by police, and maybe Michelle and Anna can comment on this as well. Sometimes it's a bit of a charged environment. These competing energies within very small spaces. Once an arrest process has begun, I would caution anyone against thoughts of physically liberating that person from police custody. Once an arrest process has begun, then the custody has been assumed. And I can only caution that because it would bring far greater danger to yourself and to whomever's custody you're trying to break free. I just don't believe. I believe it's germane to the greater cause that's being served sometimes. The second quick point was a question someone asked in the chat about should no one bring. I basically described 2 or 3 key things you should only bring to the action. Is it just those engaging in the direct action who are taking on the risk of being arrested, or is it everyone that shouldn't bring that? I believe it should be everyone, because while you're arrested as an individual, the action is part of a collective. People who have a greater movement organizing history than I do know in the not too distant past in Vancouver, VPD vans pulling up to people as they walked away. If you walk away by yourself, you're more likely to be intimidated. They can get out and they might grab you and take you into custody at that time. So I would even say when leaving an action, it's important to be in pairs or in groups. I don't know how XR's organized it, but you're most vulnerable, in fact, when you leave the action. And I'm going to say that's true, particularly of leadership.
I can add a bit to what you just said, Vic. Firstly, I'm just popping a resource in the chat, and I know we're going to discuss some other resources later, but some of the things we chatted out today are in this guide that Pivot put out around the Wet'suwet'en actions, and it contains things like a good flow chart on what to say if an officer is holding you around, like, am I being detained? Am I under arrest? I do not consent to search, those kinds of things. It also talks a bit about some of the things Vic went over in terms of like what to bring, undertakings, considerations, things like that. Going back to what Vic was just saying about where people are actually being already detained and the entire idea of like de-arresting a person. I like to kind of differentiate between, this is like a perfect example of where there's the law and there's what actually happens to people. The law is that police don't have any general authority to touch another person. They have to be acting pursuant to some specific legal right in that moment. So if you are not like arrestable as a result of them having a reasonable basis to believe that you've committed a specific crime, technically they're not allowed to touch you. And technically in that case, if somebody were to help you pull away from an officer, that would not be a crime. But what that would involve is you actually feeling so secure in your understanding of what the law is and of the evidence of what's happening in that moment, because you know what's going to happen is that cop and three of his cop friends are going to corroborate on their notes, say that you were being violent, and come up with a completely different version of events. So that's like a really good example of where like the law technically would say that there's nothing illegal about helping a person resist an illegal arrest, including physically intervening. But practically, I haven't heard of an instance where that goes well for anyone, and doesn't just result in a profound escalation and harm. So that's one thing I wanted to add about that. And then just going back to Michelle's discussion of undertakings, I think the thing that I was kind of curious about coming out of the port situation is, and a really good example of why you want to talk these things out in advance is, it's like there's talking about who's arrestable, who's non-arrestable. And then it's starting to seem like there's another conversation, which is who, because of their privilege, their comfort, their experience in the system, any number of things, is comfortable waiting for bail court in the morning to see if they can get better conditions versus who isn't and they can't. And it's one thing you can do because there are basic principles around parity where people who are arrested for the same things should generally be, outside of them having, like, for example, if somebody already is like on probation, they could be treated differently. But if people have similar criminal histories and arrested for the same thing, they should be getting the same conditions. So if people who take undertakings right from custody are getting really bad conditions, but somebody stays through to the morning and gets good one, that makes a lawyer's case or an individual's case easier to get everyone else's conditions varied, because there should be parity. Those should be the same things. So it's just an idea. I don't know how it would actually work out, but something to think about as a potential tactic for folks going forward.
I think one thing is important for us to underscore, the whole human element of being at an action and being taken into custody, is that some people, what I'm going to make a comment on is fear, which is something that most of us don't recognize in everyday life. I'm saying fear of arbitrary state authority, and that could include violent actions by police. Some of us might feel that fear just in being in proximity. Others, it might take us to actually be in a van or the back of a car. Others being processed in custody. But the idea of arming yourself with a bit of a legal education, the idea of acting as a collective, and you're acting as a collective when, like I said, you're not taking ID, you're looking out for the next person, or when you have a bit of a strategy in mind, that's the best way you can arm yourself with a course of action and with peace of mind that, hey, if I'm taken into custody, I'm not alone. Hey, if I get a summons and these terms written into it, once they've grabbed 6 of us, or I've waited 6 hours, which is exactly what Anna's talking about, I won't have as many conditions on me. There's no judgment on anyone in terms of how they react to that fear. I think you guys need to keep that in mind. And that's going to play into the decision you make is how far am I willing to go, decisions I make about being arrested. Again, it's something I applaud people for. I think it takes a lot of courage. It's quite fantastic, really. And but I think at the same time, we all have a relationship with that fear that we have to monitor and keep in mind. Because it's better than I don't prepare, I'm gung-ho, I get picked up and I'm nervous and I can start causing greater damage to people other than myself. I wanted to invite anyone that has a question for myself or Anna or Michelle to please, and it could be a particular question or personal, to please go ahead and ask.
I see a question in the chat that might be good for maybe Michelle to weigh in on a bit. I have some thoughts as well, but you're on mute.
Sorry, are we talking about the question about additional risks or?
Yeah, that question.
Okay. I mean, it kind of goes without saying, you know, the additional risks that people who are like particularly BIPOC face. When dealing with the police, we have very literal examples of people at an action. There are some white or white passing people, and there are some visible BIPOC people. And for some reason, the people who are visibly BIPOC get a little bit more roughed up than the people who are white or white passing. In terms of when people are being arrested, we have, if somebody appears as femme or looks female to the police and they're being arrested, we've seen videos where there will be a swarm of also other female police officers to extricate that person from where they are for the purposes of being arrested. Yeah, and in terms of, I think that somebody who sort of identifies as queer might be able to speak a little bit, and what has been arrested would probably be able to speak a little bit more about the risks that they faced personally when going through the arrest process. But I can give lots of anecdotal examples of, I mean, specifically where BIPOC are treated in a different way than non-BIPOC. But for women, at least, or women, or usually when they're arrested, and they'll be given a female officer to kind of deal with them. And I haven't really heard anybody particularly complain about that issue when I take the lawyer calls, so.
The things I would add, definitely heard from a lot of folks who are non-binary, trans, that there's a lot of misgendering, that for trans folks in particular, there can be serious risks in terms of where you're actually placed in cells. And that's a real thing. I think it's also important for folks just to remember that even if nothing more happens to you than other folks, like the reality is like community trauma, personal trauma means that the traumatic impact of an arrest can be completely different for somebody who comes from a certain identity, and that's real and should be honored, and respected. And I don't get the sense this is a problem here, but I think one of the reasons that we've come back to this a few times in this presentation is some groups historically have put a lot of pressure on everyone to get arrested in action and haven't had this internal dialogue among the different power dynamics and levels of privilege within a movement, how that getting arrested does not have the same impact on everybody. Adding to what Michelle was saying about BIPOC, while obviously folks who aren't BIPOC can also have this, it's often true that people from racialized communities have more responsibilities in terms of like people they're caretaking for, communities who rely on them. Being off the grid just isn't as possible. The other thing that has been raised today, that was raised around Crab Park, were Indigenous women with tenuous relationships with MCFD and kids, and just not wanting to draw attention to themselves in that way for risk of impacting their ability to parent their own kids. So there's a huge range of things, and it's just to honor that people are not facing the same harm in making these decisions, and just to have those conversations in a careful way with each other.
I think to expand on that, I think you have to think about what is my individual risk profile, meaning responsibilities I have, sensitivities, or excuse me, previous existing traumas that could be activated. The nuts and bolts of it is that once you're taken into custody, and I say this keeping in mind that I'm sure many of you have been to other actions and taken into custody before, you're not in control of your own body at that moment. And that can be a frightening and alienating feeling for a lot of people. And to prepare yourself for that psychologically is important, I believe, frankly, so that you don't activate police violence. It's about reducing that risk profile that you walked in there with. There was a question actually in the chat, Michelle, about the consequences of someone in direct action who've had previous charges, whether they've been stayed or they pled out or they were withdrawn. How could multiple offenses play into someone? So if I'm a hipster UBC grad student and I've had 3 charges, and hey, I get picked up that day, what happens to me? Does it aggravate things for me?
Yeah, so two possible situations. It could be a situation where you have this profile, you've been arrested multiple times, I'm not too sure. Yeah, conditional discharge. So there has been some convictions. What this could mean is, if you have been arrested with other people and other people who've been arrested with you under the same circumstances get their charges dropped, usually because of the public interest, you're more likely to have your charges approved. And as you go through the prosecution process, you're more likely to have a more severe sentence. So let's say, all of us get arrested, all of us get our charges approved, and the 4 out of 5 who've never done this before, they'll say conditional discharge. You won't get a criminal record. You can just do community service, and then obey your conditions for 2 more years, and then your conviction will disappear from the record. But the 5th person who's gone through this before, maybe instead of getting a conditional sentence, they'll get a suspended sentence, which is a permanent sort of mark on your criminal record. Depending on circumstances, maybe you'll face jail time when others haven't. Not the clearest example, but an example which is easy to understand is, people who get arrested in Kinder Morgan but have gone arrested multiple times will more likely get longer sentences in jail than people who've just been arrested the first time. And I'll leave it for there for now as I read through that chat question.
There's actually, I totally would welcome any of the participants themselves to, if there's any comments actually you want to make from personal experiences or shared experiences you've had. There's a couple of really good points being made in the chat right now that I'd invite you to sort of say out loud, because I think it's incredibly informative.
Does anybody want to unmute and ask? Maybe Nova?
I just saw a question from Chad Lund about employment risks. There's a lawyer who's not with us today, Gal Levitt, who's a labor and employment lawyer, and has said we're welcome to kind of ask her questions for follow-up later. The few things that I can share from sessions that she's helped teach in the past are that, in general, if you're arrested and convicted of a criminal offense, there can be an impact on your employment. Generally, if you're not actually convicted, it's pretty rare for it to impact your employment. An employer may have grounds to suspend an employee if you are charged in situations which are really serious, but they basically have to be able to establish that the continued presence of you as an employee poses a real threat to its business in some way. So the simple fact of an arrest or even a conviction, I think the overall point I've heard from Gal in previous sections is that they have to be able directly to tie that charge or that conviction to your specific employment and why it's a problem for your specific employment. Chad?
So I'm not an employee, but I have a contract. I'm a contractor. So I'm in healthcare. And annually we re-sign the contract.
Okay.
I guess that would make it more vulnerable, no?
Probably. I mean, I think that's I think what we're trying to do at MLS is build out our Q&As based on things like this. So I'd love to take that back to Gal and ask specifically about that situation. I might just drop my email in the chat, and if you wouldn't mind emailing me that question, and then we can flesh it out and send it back to you.
Chad, in a nutshell, someone would have to look at your specific employment contract, look for a discretionary or a moral clause in there.
Okay.
So
Thanks, Vic.
what Anna actually said about what the law does and doesn't do is that you'd also want to guard yourself against a rehire bias. And that we know that's happened with teachers unions in Ontario, for example, who are on rotating one-year contracts. So it's just a matter of your specific terms of employment, what they outline. There's a question also about someone bringing a teenager to an action, which is a perfectly, I think, a really great question. If you look at New York, Paris, and London, we would all be dinosaurs at some of those XR events. It is actually mostly young people.